Hi, everyone. My name is Ashley Jacobson. I'm a disability civil rights attorney, a vocational rehabilitation counselor, and a proud disabled woman. I live and work in the state of Michigan, though I do consulting throughout the United States and internationally. But I, as a disability civil rights attorney, practice in the areas of law most frequently that include employment law, education law with special education cases, as well as some long-term planning for people with disabilities through estate planning, disability benefits planning, things like that. The vast majority of my cases are employment law, education law, and juvenile law. Because you may not know that up to 80% of kids in our juvenile detention centers have disabilities. Whole other topic for another time. But it does bring up the importance as an attorney that we all understand how to make the legal process accessible for people with disabilities. And if you think that you're an attorney who will never need to worry about anything related to disability because your clients don't have disabilities, or your employees don't have disabilities, or your judges that you work with don't have disabilities, think again. It is incredibly common for clients, for other attorneys like myself, for judges to have disabilities. And so, as an attorney, you can only zealously and best represent your client if you have a foundation of how to make sure the legal process is accessible to them and that you're using appropriate language when disability comes up. And so, to assist law offices in ensuring that their processes are accessible to clients with disabilities as well as employees with disabilities, I created the 8 A's of accessibility. Now, this document is also provided for free on my website, jlapllc.com, but I'm also happy to email it to anybody who is interested. My email address is Ashley, ASHLEY, at jlapllc.com. I'm happy to share any resources that I have. I will also note we desperately need more disability civil rights attorneys, and especially if you're a law student with disabilities or you're an attorney who is also disabled, you have a unique perspective that empowers you to better serve clients. And so, if you're interested in disability civil rights, that's a niche area of law that is growing very quickly. I have never been out of clients. I've never not had a steady stream of clients come in. And so I do have another YouTube video where I explain what disability civil rights are, the areas of law that are mostly affected by them, which would be employment law, education law, estate planning, and juvenile law or criminal law. And so if you're interested in that, that's a lengthier YouTube video, but I do believe that there are a lot of gems in there. And if you want me to share that video with you directly, again, just request via email and I'm happy to send you everything that I have, but it is also going to be posted, or it is posted now on my YouTube page. Okay, so let's get into the 8 A's of accessibility. I'm gonna share my screen here. Okay. The first page of the 8 A's of accessibility just provides kind of the background that I just offered to you, so I won't read it word for word, but it explains that the disability community is the largest minority group or marginalized community in the United States. 1 in 4 US adults has some form of disability. If you're blessed with the opportunity to age, you will become one of those 1 in 4 at some point in your life. And that isn't meant to sound like a threat or be scary. I'm disabled myself. But it's just a fact of life that it is a natural part of the human experience to acquire disability, especially as you age. So it's crucial that attorneys understand this, not only because they might be interacting with clients with disabilities, but also opposing counsel and judges with disabilities as well. Okay. It sometimes can feel overwhelming, though, to know where to begin. So that's why I created the 8 A's of accessibility. You can, of course, adapt this for your needs as an attorney or somebody who runs a law office, but this is a good starting point, in my opinion. So, first A is assign. Identify who is assigned to review work or work on a case and review that person's baseline knowledge related to the disability community. I have some worksheets on this as well. So if you want some assistance in assessing your employee's understanding of disability, feel free to reach out to me. But the reason assign comes first is because we want to make sure that from the very start of the process, the person who is vetting prospective clients, who's reviewing potential cases, that they're asking the right questions to that prospective client. And those questions may be affected by the client's disability and how they answer. So you want to make sure that there are processes to ask potential clients, do you have any accessibility or accommodation needs prior to our intake? And you want to train your employees to be able to identify when a disability might be involved in how a person's answering questions or providing documents. And it's really difficult to train employees to do that without understanding their baseline knowledge of disability. Of course, you never want to ask an employee if they have a disability. It is entirely personal, private medical information. It is always up to the employee whether or not they want to disclose that they have a disability. Of course, unless they're requesting reasonable accommodations where certain disclosures can be required. But ultimately, even then, it's up to that person if they want to disclose their disability or not. But one thing that you can do is ask your staff, and even when you're onboarding new staff, ask, what knowledge do you have in serving individuals with disabilities? Do you understand what the definition of a disability is? Have you had any experience working with clients with disabilities? And going from there, we also then move to the second A of acknowledge. And this is the one that's the most difficult for anybody that I've consulted with because it requires some self-awareness. And as attorneys, we are great at telling other people what they're doing wrong and what their flaws are. And we have a harder time admitting maybe what our flaws are. And so we want to acknowledge that every human being has potential biases, right? And so with disability, what this tends to look like is we're deeply conditioned in our society to treat disabled individuals as though they are less valued members of our community, typically because there's an assumption that they're unable to work, despite the vast majority of people with disabilities being capable of working, though they face extreme and disproportionate discrimination in hiring practices. And we also need to acknowledge that disability falls at the intersection of every other type of ism we might see, whether it's racism, sexism, even, some discrimination based on sexual orientation. Disability can affect people from any group, and that includes other marginalized groups as well. And Black and disabled people, or disabled people who are not English language, first language being English speakers, that they tend to face even harsher treatment. So acknowledge what you need to learn about disability. Acknowledge that maybe your assumptions about this employee or this client who has a disability are incorrect, and then move on to the next A to see how you can appropriately assess the situation from a biopsychosocial disability perspective. And this is crucial in every area of the law because the law historically has treated disability as the medical model of disability has treated disability, where it's what are the medical symptoms that are concrete, the physical medical symptoms, because the law traditionally has not appropriately treated people with mental illness or viewed their symptoms as severe, as important to compensate for injury and things like that, unless there is physical injury as well. And so we want to look at disability from the biopsychosocial perspective. The bio, of course, is that medical background. What are the medical disability symptoms that this client experiences? The psychosocial perspective is how does this affect the person in the community? How do they navigate our law offices physically? How are they approaching conversation with their legal team? Do they best communicate using the phone, texting, email, other assistive technology devices? Do they utilize a screen reader? Do you in your office, do you have a disability accessible parking? Do you have a disability accessible restroom? These are all considerations that you have to assess holistically from that person's experience. And who is the expert in that person's experience? The person. So you want to make sure that you are not making assumptions and that you're truly hearing and listening to what that client is saying their needs are and how it's affecting them. Because I'll also tell you this, I've had multiple clients that were turned away by other attorneys because they were told they're going to have a hard time proving the injuries and the damages because maybe that person is a non-speaking individual and they use a communication device. Yet if they had only taken the time to communicate with that client using that communication device, they would know that the client can testify using that tool. And some of my most winning cases were those cases where other attorneys turned them away, where a simple 5-minute, how does this person best communicate conversation could financially and otherwise be a huge success. But because they didn't take this step to assess the client's experience and how they best navigate in our society and in our legal process, they missed out on a great case. So that leads to the next day, ask. One of the simplest and best tips for ensuring accessibility in your legal process is to ask the individual with a disability what is needed or helpful to allow full participation in the process. And if they say, I don't know, that opens the door for you to talk about the next step in the legal process, what they can expect. So for example, let's say you work with a juvenile court client and they have just been charged with a crime. They've received the notice in the mail that they've got this preliminary hearing coming up or their preliminary intake coming up at the court. And you say to this person, I understand that you're diagnosed with ADHD and you have an IEP plan at school and you know how you get a little extra time for testing and things like that. So we want to make sure that if there's anything like that that you might need for the legal process for our hearing coming up, that I'm able to request that from the court and make sure that you fully participate in this process because this process could affect you for a long time. And so when we go to this hearing, we're going to go to the physical juvenile courtroom. It has a wide doorway. There is a restroom right down the hall with a disability accessible stall. If you need a break, you can request one from me and I can notify the court. But there's a chair in the hearing room where you're going to be seated for quite some time. Do you have difficulty sitting still for long periods of time? And then kind of guide them through what that looks like and know that I've never, I hate to say never because we don't like talking in absolutes in the law, but I cannot recall a time where I requested an accommodation for a client and a judge denied it. So do not be afraid to inform the court. For example, I've had to inform a judge, Your Honor, my client has a diagnosed disability that makes being seated difficult for long periods of time. As such, I've provided him with a fidget tool that he has in his hands. So if Your Honor is okay with him holding that in his hands, as long as it's not disruptive to the proceedings, would the court oblige us on that? And typically, they've always said yes. But it might mean scheduling restroom breaks for clients who have chronic illness. It might mean ensuring that when there are breaks, there is a dark room, maybe a conference room at the courthouse where they can sit with the lights off to decompress for a few minutes before going back in there. Perhaps if there's a child with a disability who is the victim of a crime, who's testifying, there are certain emotional support animals that courts tend to employ to make the child more comfortable. So for each area of law, you want to make sure that you're painting the picture of what that process looks like for the client, and then asking them, what do you need to best participate in this process? The next A is adapt. You want to adapt your methods to the disability of the individual to allow equal participation and protection of disability rights. So again, those were just some of the things that I was talking about before. If the person says, I focus better if I have something in my hands, you adapt by giving them a fidget tool. If a person says, I have really bad nausea from my chronic illness, and I'm worried that under the stress of this court hearing, it's going to act up, then maybe you adapt by saying to the client, I'm going to give you a piece of paper and a pen during the hearing. If you start to feel nauseated, I want you to write down restroom or whatever you want to get the information to me that you need a break, you know? And so you want to adapt that process. You also want to make sure that your client is appropriately accommodated throughout the legal process. So accommodations, I differentiate that from adapting only because when you accommodate, that's a specific term under disability rights laws that do not mean special treatment. I hear that a lot from attorneys and even from some judges and things like that, where they say, well, why should this person get special treatment? Or they've been charged with a crime. Why do we need to bend over backwards for them? Or that's going to take too long to use their assistive technology communication device in mediation to go back and forth and wait for them to have a response. So you want to ensure that whether it's with the mediator, with the court, that you are in writing requesting that the client be accommodated for their disability, of course, with the client's consent. And if you don't do this, and the client's case does not have a favorable outcome, you as the attorney could get into some trouble. They could appeal the decision, and it also just doesn't look great to judges if the client has especially a readily apparent disability and their attorney seems to be ignoring it. So overall, you want to make sure that you're requesting accommodations in writing, usually via email, through the court or with the mediator to ensure that everybody understands these accommodations will be followed throughout the process. Now, one accommodation that I'm seeing more and more frequently is the ability to participate in hearings via Zoom rather than in person. Some judges do push back on that because they prefer to be in person. There is a delicate way to word that email in stating something like, good afternoon. I absolutely understand that it's the court's preference that we attend hearings in person. That being said, my client does have a disability, is diagnosed with X, whatever that disability is, and I am requesting an ADA accommodation for their disability, which includes, their ability to wear a hat during the court proceeding. I've had clients, due to sensory needs, they wear like weighted clothing or hats to help with the physical sensations that they're feeling when they're seated in court. I've had clients who need ASL interpreters who require court documents in larger fonts. So usually like SCAO, or each state, has their forms that they use, whether it's probate court, juvenile court, criminal court, with, waiving arraignments and such. But you want to make sure that your client understands the vocabulary and is able to consume that information. And so you typically will request accommodations in writing as soon as you become aware of them, but you may have to remind people throughout the process that these accommodations are in place as well. The next A, assist. So you want to assist the individual, but something that I see attorneys do often, because we are so busy, understandably, is they tend to rush their clients. And I get why I've fallen into that habit at times as well. But especially when a client has a disability where maybe you ask them a question and it takes them a couple of extra seconds for them to cognitively process what you've asked and then formulate the wording for how they want to respond and then share that. And I've seen attorneys get impatient and miss out on crucial answers from their clients that could have helped them in court had they just taken a beat and not rushed the client. Now, of course, we're all under certain time constraints. I understand that. But that's where preparation is key. And once you get into the habit of doing these things, it's really second nature. I promise you, it won't even be something you'll think about eventually once you build accessibility into your process. Okay, and the last A, analyze. So after each step in a case, but also certainly at the end of a case, you want to assess, what was the outcome of the case? Would I have done anything differently? And try to think of what you did that worked and what you did that didn't work for this individual with their disability. And keep that in mind for future clients while acknowledging that two people with the same disability might have different symptoms and different experiences. So you should always have an individualized approach. But when you build in these accessibility checks and balances in your law practice, you'll find that the physical environment of your office is more accessible to people with disabilities, but also that you're more approachable to a wider net of paying clients with great cases that are financially lucrative. Okay, so I'm going to stop sharing because those are the 8 A's of accessibility. And like I said, if you have any questions about any of this, let me know. I do have 8 A's of accessibility for other fields as well, whether it's the 8 A's of accessibility for police and prosecutors, the 8 A's of accessibility for mediators or arbitrators, and obviously this general 8 A's of accessibility for attorneys. But you really can customize it to your own needs. And I hope that you found this helpful. Again, my name is Ashley Jacobson. My email is Ashley, ASHLEY, at JLAPLLC.com. And my phone number is 248-878-6940. You can call, text, or RTT me, and you can email with any questions, concerns, or needs. Thank you so much. I really greatly appreciate your interest in this topic, and I firmly believe that it will benefit you, your office, and your clients in the future. Have a great day.